management of retirement funds. This is part of the Class 4 of Class of Business that we are covering at the moment. Let's have a look at the Management Board, which is Section 7A of the Pension Fund Act of 1956, and the definition of a trustee. A trustee is a person who holds assets for the benefit of beneficiaries and manages the fund and its assets in terms of the rules of the fund. Section 7A of the Act provides for the following. 1. Every fund shall have a board consisting of at least 4 board members, at least 50% of whom the members of the fund shall have the right to elect. The constitution of a board, the election procedures of the members, the appointment and terms of office of the members, the procedures at the meetings, the voting rights of members, the quorum for the meeting, the breaking of deadlocks, and the powers of the board shall be set out in the rules of the fund. Provided that if the board consists of 4 members or less, all the members shall constitute a quorum at a meeting. Number 2, a board member appointed or elected must attain such levels of skills and training as prescribed by the registrar within 6 months from the date of the board member's appointment. 3, a board member must A, within 21 days of removal as a board member for reasons other than expiration of the board member's term or of appointment or voluntary resignation, submit a written report to the registrar detailing the board member's perceived reasons for terminating. And B, on becoming aware of any material matter relating to the affairs of the pension fund which, in the opinion of the board member, may seriously prejudice the financial viability of the fund or its members, inform the registrar thereof in writing. Right, the duties of the management of the board, Section 7D of the Act. A, ensure that proper registers, books, and records of operation of the fund are kept, inclusive of proper minutes of all resolutions passed by the board. B, ensure that proper control systems are employed by or on behalf of the board. C, ensure that adequate and appropriate information is communicated to the members and beneficiaries of the fund, informing them of their rights, benefits, and duties in terms of the rules of the fund, subject to such disclosure requirements as may be prescribed. D, take all reasonable steps to ensure that contributions are paid timeously to the fund. E, obtain expert advice on matters where the board members may not have sufficient expertise. F, ensure that the rules, the operation and administration of the fund comply with the Pension Funds Act, the Financial Institutions Protection of Funds Act of 2001, and all other applicable laws. And G, comply with other prescribed requirements. Right, the roles and the responsibilities of the trustees. Here we look at some general principles. A, management of retirement funds in compliance with the rules of the fund and the Act. All decisions and actions are taken according to the Act and the rules of the fund. B, acting in the best interest of members of the fund, especially with regard to investment returns, to ensure that members receive the best returns on the investment funds by having prudent in the investment process, ensuring that that all assets of the fund are not abused and that they do not become open for bribery. Trustees must not accept bribes, gifts, presents, discounts in exchange for the appointment of service providers. D, the Board of Trustees and its committees must carry out its responsibilities for the benefit of members and not for their personal gain. E, ensure that the fund is managed transparently and fairly and that there is adherence to the rules of the fund and the relevant legislation. Playing a constructive role in ensuring the role of trustees is well understood, kept up to date with the trends, developments, and topical issues in the retirement fund industry to improve on self-development as a trustee and share their knowledge with others, especially fellow trustees and fund members. And the final point here, exploring different investment strategies and policies to ensure that members' funds are invested most suitably to provide benefits contained in the register rules of the fund. Right, if we look at the trustees' duties and responsibilities, and we just summarize that in this specific diagram. First, execute in accordance with the law, act in interest of the beneficiaries, act fairly between beneficiaries, act prudently, seek advice, and maintain confidentiality. I'm not going to read all the fine print there in the blocks, but you can go through that. Let's have a look at the fundamental principles of retirement funds. Now, there's a couple of principles here. Principle 1, retirement funds are separate legal entities. The fund is separate from the sponsoring body, be it the employer, the union, or the service provider. It can sue and can be sued in its own right. The second principle is that trustees make decisions. The fund is directed and controlled and overseen by the board of trustees or the management board, including good governance, administration, management of services, providers, and the designing of benefit structures, usually with the help of the fund consultant. Principle 3 is the fund rules are king. The trustees are not permitted to do anything outside the registered rules of the fund. All benefits and contributions must be in terms of the fund and should be in terms of the rules and the Pension Funds Act. However, trustees have limited discretionary powers, and sometimes, especially where the rules are silent. Principle 4, membership in the fund is compulsory for all eligible employees. An organization with a retirement fund must make it a condition of employment for all employees who join the organization, as long as they meet the eligibility criteria. Principle 5, funds are designed with the sole purpose of providing retirement benefits and or risk benefits. The sole purpose of a retirement fund is to provide retirement benefits. All other considerations are secondary to this duty. The trustee should therefore ensure that provisions are in place to safeguard this specific requirement. Who may act? The selection and the appointment of trustees, other than certain persons listed below that we'll discuss, who are prohibited by law from acting as trustees. Any individual, provided the rules allow, may act as a retirement fund trustee. As this is a position of responsibility, an individual's qualification, experience, and character traits of honesty and integrity are critical factors to consider this person and selecting them as trustees. Let's have a look at the different types of trustees. You get the member elected trustee. The fund members then elect these trustees. You get an employer appointed trustees. That's where the employer appoints those trustees. Then you get professional or independent trustees. Independent trustees are those trustees who are not employed or controlled by the employer or its employees or any organization which acts on behalf of the members of the fund. Independent trustees are usually appointed to funds like umbrella funds, where there is a need for an independent opinion as the administrator, the sponsor, that is appointed as the trustee. The following persons are prohibited to act as trustees. Unrehabilitated insolvent individual. I mean, that's obvious. I mean, you can't look after your own financial affairs. How would you look after the fund's affairs? Persons who have undischarged obligations under composition of arrangements made with their creditors. Persons of unsound mind may not be appointed as a trustee because they lack the necessary legal and mental capacity to conduct the affairs of the trust, and then persons convicted of an offence involving fraud or dishonesty. We said that the trustee must be honest and of good standing, and obviously all four of these individuals do not qualify. Managing conflict of interest in the retirement funds. A conflict of interest is identified as any situation that can undermine a person's impartiality because of the possibility of a clash between the person's self-interest and professional interest or public interest. Conflict of interest should not necessarily prevent trustees from acting in good faith in situations where trustees are conscious of a possible conflict of interest. It may be necessary before a decision is taken to obtain legal or other professional advice as appropriate. Any person appointed as a trustee could be in a position where there may be a conflict of interest between their duty as a trustee and their other interests. Their duty as a trustee must prevail when making decisions. A conflict of interest cannot be avoided totally, but needs to be acknowledged and managed accordingly. Here are some examples of conflicts of interest. The first one, trustees appointed directly by the employer may include members of the company's board and senior management, and as such, finance and human resource executives. Such persons may experience a conflict of interest between their duty to the company and their duty as a trustee as they seek to balance the two roles. This could arise from, for example, where the company is experiencing financial difficulties and where considerations is being given to a proposal of a loan to the company. The second one is conflict of interest may also arise in the case of trade union officials acting as trustees, where they could believe they are appointed to represent a particular faction or a group. Thirdly, trustees may also include members of the fund. Such persons may experience a conflict of interest concerning the payment of benefits where the trustees have discretion and their colleagues are involved. Trustees are not to profit from the fund. I mean, that's clear. A clear conflict of interest would arise if a trustee profits from the fund's assets or the decisions they make. Trustees should not profit from their fund, whether directly through being paid for their work or indirectly through using information gained as trustees for the ends, unless the rule specifically provides that the trustee may be paid for carrying out their duties. Trustees are to be reimbursed for costs incurred while carrying out fund business. Right, trustees' liability and protection. Section 7 of the Pension Funds Act affords trustees protection from liability. In any proceedings against a board member in terms of this act, other than for the willful misconduct or willful breach of trust, the court may relieve the board member from any liability, either wholly or partly, on terms that the court considers just, if it appears to the court that a board member has acted independently, honestly, and reasonably, or B, having regard to all the circumstances of the case, including those connected with the appointment of the board member, it would be fair to excuse the board member. A breach of trust. If trustees act in a way not authorized by the rules, or if they fail to do something which should have been done under the same provisions, this could be called a breach of trust. All the trustees are individually and collectively liable for any breach of trust. Even if a trustee were not directly responsible for a breach of trust, they could be sued. It is found that trustees have committed a breach of trust which result in a loss of fund assets or prejudice to any other stakeholder. They will be personally liable to restore the loss. However, a mere error of judgment is not in itself a breach of trust, and trustees are presumed to have acted honestly and properly until the contrary is shown. Suppose a breach of trust does result in a loss to the fund and a claim is lodged against the trustee. In that case, they may rely on the protection afforded by any relevant statutory provisions or by an exclusion clause or intermediary clause contained in the rules. If their defense is unsuccessful, the fund's fidelity policy should indemnify them against claims. Most funds take out insurance against trustees' liabilities. However, it is essential to take advice from a specialist who understands this type of insurance. It should be noted that through a trustee may be legally removed, he or she remains liable for any decisions they took when acting as a trustee. From the trustee's perspective, it is therefore important that any indemnity insurance will cover them for a suitable period after they have ceased to be a trustee. Fidelity cover, protection that can be taken out. This is a short-term insurance policy which provides against losses caused by wrongful acts of officials of an organization in carrying out their duties. In retirement fund terms, it is generally insurance against losses incurred by the fund and hence the members as a result of people who have access to contributions or fund assets helping themselves, in this case fraud and theft, but could also cover such things as benefits paid to the incorrect party, which cannot be recovered. In terms of the Pension Funds Act, funds are required to effect a policy of insurance to indemnify the fund against losses due to the dishonest or fraud or any other of its officials. The limits of indemnity and the levels of cover are not prescribed, and the trustees need to make a decision regarding these issues themselves. Right. Pension Fund Directive 8, prohibition of acceptance of gratification. Officials of and service providers to a fund must not be involved in any conduct constituting bribery, fraud, or corruption, or any such involvement will have a bearing on such person's fitness and propriety to hold office. Issues that may prejudice a fund or its members must be reported to the registrar. Corrupt transactions must be reported to the police. The directive defines what constitutes gratification. The defined types of gratification may not be accepted at all by fund officials and service providers unless the registrar agrees in advance that they can be accepted. Now, what qualifies as gratification in Directive 8? Gratification means first, money, whether in cash or otherwise. Two, any donation, gift, loan, fee, reward, valuable security, property or interest in the property of any description, whether movable or immovable, or any other similar advantage. Three, the avoidance of a loss, liability, penalty, forfeiture, punishment, or other disadvantages. Four, any office, status, honor, employment, contract of employment or service, or any agreement to give employment or render services in any capacity and residential or holiday accommodation. Five, any payment, release, discharge, or liquidation of any loan, obligation, or any other liability, whether it is in whole or in part. Six, any forbearance to demand any money or money worth of any valuable thing, any other service or favor or advantage, or any description including protection from a penalty or disability incurred or apprehended, or from any action or proceedings of a disciplinary, civil, or criminal nature, whether already instituted, and includes the exercise of the forbearance from the exercise of any right of any official power or duty. 8, any right or privilege. 9, any real or pretended aid, vote, consent, influence, or abstention from voting. Or 10, any valuable consideration or benefit of any kind, including any discount, commission, rebate, bonus, deduction, or percentage. So you can see they've really covered what qualifies as a gratification quite comprehensively in Directive 8. Gratification then excludes remuneration paid by a sponsor of a fund to a trustee appointed by that sponsor of a fund. Trustees' qualifications and experience. As stated in the introduction, trustees are generally drawn from the company managers and other employees. Trustees may not possess the necessary expertise to carry out all the specified duties without the assistance of qualified advisors. A particular example is the investment of fund resources. Trustees of a fund are required to possess, employ, or enter arrangement with advisors who possess qualifications and experience appropriate and relevant to investment of the fund's resources. Trustees are regarded as executing their duties by appointing an investment manager to manage the investments of those resources. Right, as far as training of trustees are concerned, um, they need to know about the Pension Law, Marriage Act, Divorce Act, Child Maintenance Act, taxation, investment regulations. They need to know about life stage investments, individual member choice, single manager, multi-manager, alternative investments. They need to know about corporate governance, risk management, environmental, societal, responsible investments, and also financial statements, actuarial valuations, reports, investment reports, administrative reports, and death benefit distributions. You can see there's a lot of knowledge that is needed for a trustee to act in the role of a trustee. Uh, Pensions are difficult and complex area. Trustees should ask questions when they are unsure of any issue. The most important and effective way to ensure a successful trusteeship is through suitable trustee training. The responsibility of trustees, the implication of the fund rules, and a basic understanding of funds finances, fund investment, fund governance, and fund reports should be covered in such training. It will make trustees aware of the background law and give them a good knowledge base to enable them to carry out their duties efficiently without unnecessary worry. It should also help to minimize the trustees' exposure to any legal liability. In most countries, minimum qualifications are now being imposed to ensure that boards are sufficiently equipped. Where possible, independent and professional training should be engaged rather than relying on pension fund service providers to provide training, because there is an inherent conflict of interest, as training may be restricted only to product and services offered by that specific provider. Trustees must not have an overview of the entire market and available options. What is the cost of training? Trustees should be aware that it is acceptable that reasonable costs and expenses incurred in receiving appropriate training on their duties and responsibilities as trustees should be met from the resources of the fund, as this is meant to improve the efficiency in the running of the fund and not for personal gain. Trustees' decision making. In practice, trustees are expected to make prudent decisions about the management of the fund and, in particular, must give express effect to the provisions of the rules. Trustees will also need to be conscious of areas where decisions to be taken are at the discretion of the trustees solely or require input from another party, such as the employer. It is also possible that the rules may specify a requirement for consultation with a third party before making a decision. Sometimes the views of the member and the employer may be very relevant to the matter at hand. For example, securing benefits on wind-up, which would affect members, or make a decision to change the employer contribution rate, which would affect the employer. Such factors should be taken into account by the trustees when reaching a decision. Trustees should exercise their judgment and not automatically act according to the wishes of the employer, any group of members, or even all the members. That is not to say that trustees should ignore the views of the employer or the members. They should listen to them carefully, but in the end, they should make up their minds as to what will be best served for the interest of the fund. Right, delegation of trustees' powers and duties. No trustee can carry out all of the functions and the day-to-day administration tasks Trustees will therefore be expected to delegate some of the functions. Trustees, however, remain responsible and accountable for the execution of the delegated task, be it administration, investment, or legal or actuarial services rendered on behalf of the fund. Trustees must therefore take great care in selecting the person or the organization to which they delegate a specific function and must monitor and review the actions of that person or organization. Depending on the nature and circumstances of the fund, typically the other functions delegated to a third party administrator would include the following. And the list that I'm going to give you now is not exhaustive, but here is some items. Number one, the drafting and the registration of the fund rules with the registrar and the payment of the relevant fees. Two, collection and payment of contribution to appropriate parties. Three, investment and custody of the fund's assets. Four, where applicable, the preparation and maintenance of the investment policy statement, the IPS. Five, the payments of benefits. Six, furnishing and information to the actuary auditor in connection with actuarial valuation and the audit of accounts. Seven, deduction payments of tax on benefits to the Revenue Authority, SARS in this case. Eight, seeking advice from the actuary where required under the rules, and then distributing of death benefits. Right, conducting trustee meetings. The trustee meeting is one of the most important methods by which trustees discharge the function. Trustees need to hold regular meetings to review the operation of the fund and supervise the actions of the administrators, the investment managers, and advisors to whom they have delegated many of the functions. The trustee meeting also serves as the main forum for trustees to exercise their discretionary powers where the rules are not specific about the course of action trustees should take in reaching a particular decision, or where the rules give trustees some discretionary powers. The frequency and the timing of the meetings. The rules are normally specific how often trustees must hold trustee meetings, but if not, it's a matter to be decided by the trustees regarding the circumstances. The trustees of all funds need to meet sometime after the fund year end to consider such item as the trustees' annual report, the fund accounts, and perhaps auditor's report, the report from the investment manager, etc. Other items such as the need to exercise discretionary powers following the death of a member could require a meeting at any time of the year. The size and the complexity of the fund may also be factors in deciding how often trustees need to meet. As an absolute minimum, trustees should meet at least twice a year. The meeting structure for this specific meeting, the agenda for the trustee meeting, will contain a summary of the main points for discussion at the meeting, which the needs of the fund will dedicate. The agenda will usually be prepared by the Secretary of the Board of Trustees. A typical agenda might look something like this. Number one, circulation of attendance register. Two, confirmation of quorum. Three, minutes of the previous meeting for approval. Four, matters arising from the previous meeting. And five, the administrator's report. Six, the fund finances, financial statements, cash flow, and actuarial valuation report. Seven, investment manager's report and review. Eight, the legal and compliance matters. Nine, fund policies. And 10, discretionary matters regarding industry updates. Right, recording decisions. Does any decision at a meeting requires a quorum to be present, and the rules should specify how many trustees must be present to form a quorum. The notice of the meeting agenda and full supporting paperwork should be distributed by the secretary, ideally at least 7 days before each meeting, but in any event in time to allow the trustees to prepare themselves for the meeting. Trustees should also ensure that all decisions are properly minuted and distributed to all the relevant stakeholders. The removal or the suspension of trustees. Trustees can be removed in cases where one, they have failed to comply with their duties imposed on them by law. 2, they have been convicted of any criminal activities. 3, they have left the employer. 4, the fund is being or has been administered in such a manner as to jeopardize the rights and the interests of members of the fund. Under these circumstances, the registrar has the power to suspend the board of trustees and appoint an interim board of trustees. 5, they fail to meet the minimum qualification and experience requirements as set by the registrar, and they are not re-elected or reappointed. Right, so that concludes our session on the management of retirement funds. Our next session will be Unit 6. We will look at retirement fund investments. Thank you so much for attending this session.